Hello everyone and welcome back to Law Statistics. Today's presentation is based on stages of crime. So, what are the various stages of crime? How attempt differs from preparation? Explain mens rea. Generally, an offense passes through the following four stages, which are as follows: conceiving the idea of performing a legally defined harm or mens rea, preparation for crime, attempt to commit an offense, and the fourth and the most important stage is the commission of an offense. Now, conceiving the idea of performing legally defined harm or mens rea. At these stages, a person consolidates his devious ideas, identifies ways of doing it. There is no action taken and there is no harm done to anybody, nor is there any intention to cause injury to anybody. Mens rea or bad intention is a significant progress from mere deliberation towards actual commission of the crime. At this stage, the person has made up his mind to actually implement or execute his devious plan. There is an intention to cause harm, but he hasn't yet taken any action that manifests that intention. Actus non facit reum nisi mens et rea. This doctrine, which means that a guilty act together with a guilty mind constitute a crime. Thus, actus reus, the result prohibited by law, and here the meaning of mens rea is the guilty mind. There is need of both to constitute a crime. Now, if we talk about preparation for crime, preparation consists of arranging or building things that are needed to commit the crime. At this stage, the intention to cause harm starts, manifesting itself in the form of physical actions. At this stage, it is, however, possible for the person to abandon his course of action without causing any harm to anyone. Generally, preparation is itself alone not a crime because it cannot be proved beyond doubt the goal of preparation. For example, buying matchbox and kerosene oil to burn a house alone cannot be determined as an offense altogether. However, certain preparations for committing an offense are of crime are collecting arms with an intention of waging war against the government of India under section 122, preparing to commit depredation on territories of any power in alliance or at peace with the government of India under section 126 of IPC. Now, counterfeiting operations for currency under section 235, and last one is the preparation to commit dacoity under section 399 of IPC 1860. Now, attempt to commit an offense. This is another stage. This stage is attained by performing physical actions that, if left unstopped, cause or are bound to cause injury to someone. Since the intention of the person can be determined without doubt from his actions, an attempt to commit a crime is bound to happen, and prevention of crime is equally important for healthy society. For example, according to section 307, if a person in, intentionally does something to kill another, and if the other person is not killed, he would be liable for attempt to murder. However, his action must be capable of killing. It is also clear that a person is liable under this section even if no injury is caused to anyone. However, if hurt is caused, the punishment is more severe. Case laws: Om Prakash vs. State of Punjab, the case of 1961. State of Maharashtra vs. Balram Bhanap Patil, the case of 1983, where attempts are dealt with in IPC in three ways. Section 196 and 197 deal with the offense as well as an attempt for that offense. Section 307 and 308 deal with an attempt of an offense. And lastly, Section 511 deal with the attempt for offenses. Those are not covered in the Act. Now, the difference between preparation and attempt. Both preparation and attempt are the physical manifestations of the crime intention. There is a very fine line between preparation and attempt. An attempt goes a lot further than preparation towards the actual happening of crime. In preparation, there is a possibility that the person may abandon his plan, but attempt leaves no room for that. In general, preparation involves collecting material sources, planning for committing an act, Now, if we talk about the distinction between preparation and attempt, basically, there are four tests that can distinguish between preparation and attempt clearly. They are proximity rule or last step test. As per this test, anything short of last step is preparation and not an attempt. This is because as long as there is a step remaining for completion of the crime. Theory of impossibility or indispensable element test. As per this test, all of indispensable elements must be present to equal attempt. If there is something a person needs to commit the crime but it is not present, then it is not an attempt. Interruption test. If the action proves that the person would have gone through with the plan if not for the interruption, such an arrest, then it is an attempt. If a person has not been interrupted, he would have committed the crime. He is guilty of attempt even though the past step of the crime has not been performed. On the job or unequivocality test. If a person does something that shows his commitment to follow through and commit the crime, then it is an attempt. So, attempt is done when the offender takes deliberate and oversteps that show an unequivocal intention to commit the offense, even if the step is not the penultimate one. Here, a very important case law is State of Maharashtra versus Muhammad Yaqub. That's all for today's presentation. Thank you and have a great day ahead.